principal lawyer at Leo Lawyers. Though this looks and sounds like me, what you're watching is my AI avatar presenting from a script that I've written and approved. Today, I want to walk you through what could potentially be one of the largest general protections claims in Australian history involving Jackie O Henderson. This case raises some very important issues about workplace rights, adverse action, and the scope of general protections under the Fair Work Act, particularly where contractors are involved. Let's start with the background. It is alleged that Jackie O Henderson and her company, Henderson Media Pty Limited, entered into a broadcast services agreement with Commonwealth Broadcasting Corporation Pty Limited, which is part of the ARN Media Group. Under that agreement, Henderson Media was engaged as an independent contractor, and Jackie O Henderson herself was an employee of Henderson Media. The arrangement was that Henderson Media and Henderson would provide program services for the ARN breakfast show, the Kyle and Jackie O Show. It is then alleged that between August and September 2025, Henderson made complaints about offensive and degrading comments made on air by her co-host, Kyle Sandilands. Further comments were allegedly made on 20th February 2026. The key allegation is that CBC did not intervene or stop that conduct. Henderson then sent text messages on 21st February 2026 raising concerns, and her lawyers followed up with a formal letter on 26 February 2026. That letter alleged bullying and pointed to obligations under the Work Health and Safety Act 2011 to provide a safe working environment. Importantly, Henderson claims that this letter constituted the exercise of a workplace right under the Fair Work Act. Then, on 3rd March 2026, CBC's lawyers responded, and Henderson alleges that response amounted to repudiation of the agreement and adverse action. As a result, Henderson is claiming significant damages. These include loss of fees under the agreement, which are alleged to be $82.25 million plus GST, as well as loss of future revenue opportunities. She is also claiming damage to her reputation, career, and professional standing, along with damages for pain, suffering, humiliation, and distress. In addition, there are claims for breach of contract and misleading and deceptive conduct. To understand the significance of this case, we need to look at the general protections regime under the Fair Work Act. Under Section 340, a person must not take adverse action against another person because they have a workplace right. Section 341 tells us that a workplace right includes being entitled to the benefit of a workplace law, and Section 342 defines what adverse action actually is. Importantly, adverse action is not limited to employers and employees. It extends to situations where a principal takes action against an independent contractor. In this case, it is alleged that CBC took adverse action by terminating the agreement because Henderson exercised her workplace right to a safe environment. One of the most important aspects of general protections claims is this: unlike unfair dismissal claims, there is no cap on damages. In unfair dismissal matters, compensation is generally limited to 26 weeks of pay, but in general protections claims, there is no such limitation. That's why claims like this can reach very significant figures. Looking at previous cases helps put this into perspective. In Leggett v. Hawkesbury Race Club Limited, the applicant was awarded over $2.25 million, with approximately $1.77 million arising from the general protections claim alone. That included compensation for pain and suffering, as well as past and future loss of income. On the other hand, in Ruhi-Zadigan Vive Technology 1 Limited, the applicant initially sought $55 million. However, after appeal and retrial, the claim ultimately failed because the dismissal was found to be performance-related, so these cases can go both ways, but the potential exposure is very high. There are a few important takeaways from this case. First, general protections claims are not limited to employees. They can extend to independent contractors and even prospective employees. Second, there is no cap on damages, which significantly increases the financial risk. And third, successful claims can include compensation for lost income, future opportunities, pain and suffering, and even civil penalties. This case highlights how powerful general protections claims can be where workplace rights and safety intersect with commercial agreements. It also shows how critical it is for businesses to respond carefully when workplace complaints are raised. At Leo Lawyers, we regularly advise on general protections claims, workplace disputes, and contractual enforcement. If you believe you may have a claim, or if you are defending one, you'll find our contact details in the description box, or you can visit us at leolawyers.com.au. Thank you for watching this legal breakdown from Leo Lawyers.